Hey everybody, thanks for joining for another edition of Will Wednesdays. I'm your host, Greg Davis with Tri-City Lawyers here in Durham, North Carolina. This week's topic is 3 reasons to consider a revocable trust. Now you might be thinking, well, trusts, Greg, are for really wealthy people, and that's not the case. It can definitely be for wealthy people, but there can also be reasons why someone who's not necessarily wealthy can benefit from a revocable trust. But first, a brief disclaimer. The information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials presented are for general informational purposes only. Viewers of this presentation should contact their attorney to obtain advice with respect to any particular legal matter. No reader, user, or browser of this presentation should act or refrain from acting on the basis of information in this presentation without first seeking legal advice from counsel in the relevant jurisdiction. Now, the number one reason that most people consider a revocable trust, let's talk a little bit about what that is. A revocable trust is essentially a legal document, and that legal document represents an entity. So when you buy a house, for example, and you buy a house in your name, then you are the entity buying that home. But you can also create a trust, and this trust has rules and parameters around it that are recognized by law, by statute in your particular state. So for example, there's a North Carolina statute that represents trusts. So instead of buying a home in your name, you could have a home held in the name of your trust. Now, what are some of the benefits of that? Well, one of them is being able to avoid probate. Greg, what is probate? I've heard about it. What exactly is it? Well, probate is a court-ordered process where they're trying to determine the validity of a will, and then they're trying to work with the executor or personal representative of the estate to distribute assets from that estate. Now, I like to always say everybody has an estate. Everybody has an estate, okay? And when you pass away, that's when you really have to now take account of that estate. Well, not you, but your executor or personal representative. And that's quite an involved process. You have to take an inventory of assets. That means what's the value of the car? What's the value of anything that you might own, like jewelry or furniture? What money that you have in your bank account, your brokerage account? All that has to be documented. Somebody has to reach out to creditors. Somebody has to make sure that there's an ad run in the newspaper. This is all part of the probate process before distributions occur. To avoid probate, you can do that if you own your assets in a trust, okay? Now, this is very important for anyone that owns a piece of property out of state. For example, I live in North Carolina. If I own any real estate outside North Carolina and I passed away, if that property is in my name, then that home in that other state has to go through probate in that other state. A great way to avoid probate in another state is to have that property owned outside of your home state in a trust. Another reason to consider putting property into a trust is due to incapacity. Now you might say, well, Greg, I heard about a general power of attorney. If I have a general power of attorney, then that person can step in and make decisions on my behalf. Now, if that's very true, how it's different is that with a trust, you get to define the parameters within which a person can operate. A general power of attorney tends to be more of a blanket general grant of power, but in a trust you can say, well, I'm incapacitated, but I want you to do X, Y, and Z for me, and that's it. So the trust, how it's different is it sets up parameters, boundaries within which a person can act. So we talked about avoiding probate, we talked about incapacity. A third reason why you want to consider a revocable trust is if you are a person who might be dealing with estate tax issues. Now, there's a lot going on in the world of estate planning and estate taxes, and estate taxes really only apply to individuals who have a net worth of $11.7 million or greater, which doesn't apply to a lot of people, but you never know who you're talking to who might have that issue. And in addition, while this year it's 11.7 million, rules change all the time. So if laws change, if Congress passes some laws, and let's say that federal estate tax exclusion number drops from 11.7 to, let's say, 4 or 5 million, then someone who said, well, that's not an issue for me, I'm not even close, all of a sudden, the game might look a little bit different. So there's definitely things you can do inside of a trust, a revocable trust, to avoid estate taxes. One last thing, you might have heard a distinction between an irrevocable trust and a revocable trust. The major difference is with the irrevocable trust, technically speaking, that trust cannot be changed. And once you put assets into an irrevocable trust, that's it, it's gone forever, technically speaking. With a revocable trust is created while you're alive, and while you're alive, you can make changes to that trust. If you buy more assets, you want to put it into the trust. If you sell some assets, you want to take those out of the trust. Those changes can all be made while you're alive. Here at Trusted Lawyers, we always want to encourage our clients to consider creating or updating their essential estate planning documents, their will, general power of attorney, healthcare power of attorney, your living will, and don't forget that all-important digital asset checklist. As I always like to say, everyone has an estate, everyone, but not everyone has a plan. Let's work together or work with a professional in your area to get your plan together. This is Greg Davis with Tri-City Lawyers. Will Wednesdays. I'll see you next week. Thanks for joining.